Viewers, mature societies with a deep commitment to equality and fraternity resolve disputes, particularly seemingly intractable ones, in two time-tested ways. First, by setting up a time-bound arbitration process that draws the two contesting sides into a structured dialogue to agree upon a preset objective. Second, through the courts. In fact, some of India's most thorny issues like territorial disputes, identity-related conflicts, and even differences over natural resources have been settled by our courts. So one would think that a dispute over something as fundamental, as divisive, as religious belief would be best adjudicated by a court intent upon a free and fair examination of facts. Hindu petitioners believe that the Idgah Mosque in Mathura has been constructed over the raised remains of a temple built to consecrate the birthplace of Lord Krishna. Muslim petitioners say this is untrue, that Hindu petitioners have made up a story to claim that Mughal regent Aurangzeb demolished a structure in a fit of bigotry. To square the claims, the Allahabad High Court took a most sensible step. It has ordered a court-monitored archaeological survey of the contested site. But instead of welcoming the move, the masjid side rushed to the courts to stall the move. Thankfully, the Supreme Court hasn't yet stayed the decision of conducting the survey. The masjid side has raised a clutchful of objections. Let me take you through some of their objections, viewers. It says that the Places of Worship Act bars pleas to alter religious sites. Now, if you remember, viewers, this Places of Worship Act was passed, turned into a law in 1991. And what does it say? That any dispute after 1947 on reclamation of religious sites will not be entertained by the court. So it puts a cap on any claims of a religious nature on any disputed area. The second objection, the compromise on land dispute was finalized in 1968 and court judgment to this effect was given in 1974. The third, under Limitation Act, being on land for over 12 years establishes ownership. So what they're saying is that we've been in possession of this land for over 12 years and under the law we have ownership. They point to a 1929 map highlights that the two religious places are separate. That is the Idgah Mosque and the Krishna temple. They say stand on two different sites and there's nothing below. They say nothing below the masjid to indicate that it was built on the spot where Lord Krishna was born. The masjid side also says that the petitioners, the Hindu side that is, lacks documentary evidence. Arguments have no legal backing. The petitioners are outsiders who lack ownership and links with relevant trusts. Now viewers, all these are fine. You can raise all these arguments. But one wonders why the mosque side is so averse to a fact-finding test. Nevertheless, to our dismay, the self-styled guardian of Muslim rights in India, the AIMIM chief, the man to the extreme right of your screens, Asaduddin Owaisi, has gone public with a decidedly divisive rant suggesting that the goal of the Indian state is to rob Muslims of their identity. Yes, viewers, he says this is an attempt at robbing Muslims of their identity and dignity. After Babri Masjid judgment, I had said that it will embolden Sangh Parivar's mischiefs. This is despite Place of Worship Act prohibiting such litigation. The Mathura dispute, he says, was settled decades ago by mutual consent between Masjid Committee and the temple's trust. A new group has been raking these disputes whether it is Kashi, Mathura or Lucknow, the Tiliwali Masjid, it's the same group. The Places of Worship Act is still the law in force, but this group has made a mockery of the law and the judicial process. The Supreme Court was supposed to hear this matter on January 9th. So what was the hurry? Why was a survey to be ordered? Please don't preach, he says. Give and take when one side is interested in constantly targeting Muslims. But the law doesn't matter anymore, he says. Robbing Muslims of their dignity is the only goal now. But viewers, the Owaisi is deploying the victim card to rally his constituency, his base. The hard facts suggest that it is actually Hindus who have been most often relegated to second-class status in this country. And I always bring out the hard facts for your reference, viewers, so you get closer to the truth. Let me emphasize some of those hard facts. As I said, Hindus most often end up being treated as second class. There are many hurdles that are put in the Hindu way. Let me give you some instances. Action. The Places of Worship Act 1991. What was the result of this law? Except for Ram Janmabhoomi issue, the act prevents predominantly Hindus from reclaiming temples and other sacred sites. And it militates only against them. Another action, the HR and CE Act. The result that it has led to is that the state has acquired exclusive control over Hindu religious sites. The sites of other religions are not subjected to state control. Another action, Muslim Women Protection of Rights on Divorce Act 1986. What was the result of this? It overturned the Supreme Court's Shah Bano judgment, which was a progressive judgment, awarding Shah Bano alimony. But Muslim conservatives had other ideas and they got the Rajiv Gandhi government to overturn literally the Supreme Court verdict by passing this law. Till date, viewers, no bill has been enacted to overturn several moves to codify Hindu religious practices. Despite objections of court interferences in Hindu practices, discrimination, viewers, discrimination. Another action, Sabrimala judgment. The result was that women entry was secured in Sabrimala temple against the wishes of Hindus. Because it was only in this particular temple dedicated to Lord Ayappa where women entry was banned. In every other Ayappa temple, that is not the case. And this is a particular circumstance. The appeal is now, of course, pending before the Supreme Court. Another action, viewers, Ministry of Minority Affairs was created in 2006. What was the result? Disproportionate attention on issues related to notified minorities, creating an unequal playing field. Hindus have no ministry dedicated to their welfare, viewers. In a secular state, you can't have a government working exclusively for just one denomination or two or three or four. Another action, Right to Children to Free and Compulsory Education Act 2009. What was the result? Stringent state control only over Hindu-run schools. Minority schools are exempt. And many Hindu schools have gone broke or have had problems running after this particular act came in to place. Another action, viewers, the National Education Policy of 2020 under the Narendra Modi government. What is the result? Minorities added to the list of socio-economically disadvantaged groups eligible for special aid. Again, viewers, a discrimination. Another action, Equal Rights Bill number 226. The result, Private Members Bill introduced in 2016 to end discrimination along religious lines has lapsed because no one has bothered to pass it, viewers. Now let's get to our big debate. Why is it that one side is placing obstacles in the path of Hindu belief? And why fear a truth test that can scientifically reveal what is under this particular plot of land in Mathura? It's very simple. And I want to begin this by first bringing in the AIMM spokesperson who has willy-nilly played the victim card. Sir, I have just pointed out how Hindus in this country, and there is Dr. Ranganathan here who's written a whole book on it, have been subjected to discrimination. And here, sir, you are playing the victim card, saying that, oh, this is against the dignity of Muslims. Come on, sir. Since when has ascertaining proof been against the dignity of anyone? Since when does truth blight the dignity of anyone?
Yeah. Well, Rahul, the country will run on the basis of the constitution and not on the basis of anyone's faith, whether it's yours or mine. And the constitution is clear. The Places of Worship Act 1991 was enacted with the sole intention to prevent further this kind of hatred amongst both the communities. The Places of Worship Act clearly mentions that whichever the places of worships are there prior to 15 August 1947, you cannot change the nature or character of that place. That was clear. After we were having the apprehension that this will happen time and again. Now what happened in Kashi, you started with the survey, now again you have come to Mathura, and here the one most important thing is in the year 1968, you even mentioned in your commentary that the Shahi Idgah Trust and the Sri Kashi Jagannath Seva Sangh, they entered into an agreement for settlement through court, and the courts have given a direction that yes, the things is settled amongst the parties. So if the things were settled, what was the need of taking out or wrecking up the issue now? As early matter is sub judice, matter was pending for January 9, a hearing was to be happen in the Supreme Court. But there are certain groups like the RSS, the Vishwa Hindu Parishad, they are trying to polarize the situation, they are trying to increase the hatred amongst the Muslims. See, we have been saying this time and again that since the BJP has come to power, they have already created war against the Muslim. I would say that there is hatred amongst particular community. There was no use. There was no use of getting this issue wrecked up now because it is already settled issue. But they want to create an atmosphere of polarization around during the Babri Masjid time also. The Supreme Court has clearly stated that there is no evidence that a temple was destroyed to make a mosque. That is settled.
Since
but
when?
Under Article 142, Article 142, they passed the order. So now wrecking up this issue is nothing but creating disharmony.
Let's get the other side. You made a case. You've opened the debate with some solid arguments. At least that's what they purportedly seem like. Let me bring in the other side now. Let's go first with a quick political interjection from the BJP national spokesperson, Ms. Sanju Verma. Then I want to bring in Dr. Ranganathan right after on the larger issues of how Hindus are gunning of a particular stripe for Muslims in this country. So first, Sanju Verma, your response, political response that your government, etc., is working to target Muslims and to rob them of their dignity. Sanju Verma, on that political point, a response.
Thank you. Rahul, I read a rather interesting and a brilliant piece by you on this entire issue. And I culled out a lot of information from that as well.
Thank you.
Politically, I just have to say this. First and foremost, this, entire narrative that BJP, RSS are anti-Muslim, I think that is such a fig leaf which does not, pass muster with even BJP hating, narrative peddlers. And I'll tell you why. I think this has been spoken at length, but I'll just very quickly in 10 seconds. Pradhan Mantri Ujjwala Yojana, Pradhan Mantri Kisan Samman Nidhi Yojana, Pradhan Mantri Fasal Bima Yojana, Pradhan Mantri Mudra Yojana, etc., etc. All welfare schemes of the Modi government, anywhere between 31, 33, 36 or 37% of the welfare schemes, the amount has not been only allocated, it has been disbursed to minorities, particularly Muslims. Point number one. Point number two, in Modi's first term, 3.9 crore minority children, particularly Muslims, were given free scholarships and educational facilities, and that number is 5 crore in Modi's second term, which means in the last 9.5 years, about 9 crore Muslim children and of course other minorities also have been given access to scholarships and free education, not only primary education, but also facilities in higher education, which is rather expensive. Point number three, this narrative about Places of Worship Act 1991, this Krishna Janmabhoomi Shahi Idgah Mosque, yadi pura ka pura जो कॉम्प्लेक्स है उसको हम कृष्ण जन्मभूमि बना रहे, तो दी character of the place changes. So I will just quickly say this because I believe that, let's not complicate issues. People say, oh, this Krishna Janmabhoomi issue is very complex. There's history involved, there's culture involved, there's minority rights involved, there is a legal interpretation involved. For legal interpretation, we have a veteran like Vishnu Jain here who will lay down the brass tacks. I say this is very simple, and I will just end my argument by putting out a very simple example. Rahul Shivshankar, hypothetically assume that he represents the Shahi Idgah Mosque committee. Sanju Verma represents the other side, the one that is saying that the 13.77 acres of land which is disputed belongs to the Krishna Janmabhoomi Trust. अभी हुआ क्या था 1968 में on the 12th of October? The funny thing is that the agreement was signed between the Shahi Idgah Mosque and, here very carefully, Krishna Janmabhoomi Seva Sangh, also called as Krishna Janmabhoomi Seva Sangathan, Seva Sansthan. But the catch is this: the entire 13.77 acres which is disputed was in the name of Krishna Janmabhoomi Trust. Krishna Janmabhoomi Trust is very different from Krishna Janmabhoomi Seva Sangh. So Rahul Shivshankar and Sanju Verma have signed an agreement. But what is the catch here? Sanju Verma, who apparently has bought the land from Rahul Shivshankar, did Sanju Verma have the locus standi to buy this land or come into an agreement with Rahul Shivshankar? No, because Sanju Verma to picture mein hai nahi. This land actually was under the trusteeship of Vishnu Jain, who represents the Krishna Janmabhoomi Trust. तो द पॉइंट यह है कि दो लोगों ने अग्रीमेंट कर ली, जिसमें से जो एक स्टेक होल्डर है, he was only supposed to take care of the Krishna Janmabhoomi Trust affairs.
So you're saying
Janmabhoomi Seva Sangathan did not have ownership rights, and that is, the devil is always in the detail. So
okay, let's open this up.
10 seconds more. My limited point is this. The 12th October 1968 judgment was foul because one of the stakeholders that signed the agreement did not have the locus standi or moral authority.
That's your claim.
Because
okay.
It was only caretaking on
that will be
behalf
tested.
Of another trust.
Of course, that will be tested now by a court of law. We're on, of course, the entire issue of a survey, which is, I would have thought that everyone would welcome the truth, Dr. Ranganathan, but here we are being told that the Hindus are waging war against Muslims, that this is yet another attempt to rob them of their dignity. How do you respond to Mr. Waris Pathan?
Good evening, Rahul. Waris Pathan Sahab is a very dear friend, but I have to say this, that he is peddling the narrative which is reaffirms the same old story from Martand to Mathura. That is, the Hindus have to be humiliated. The debasement of their places of worship has to be lionized, has to be shown, and they have to be subjugated, centuries upon centuries. And we have been suckers for self-flagellation. Let's accept this. So while I tell Waris Pathan Sahab, I ask him a simple question. What if the holiest of Muslim shrines was demolished and a temple built over it? Would he not ask, or at least be allowed to approach the court to demand historical injustice be corrected? I dare him to say no, but he will say yes, but as far as Hindus are concerned, he said no, let's forget about this. The holiest of Hindu places must remain humiliation, heaped upon humiliation, so that Hindus can see that the holiest of places, like it was the case in Ram Janmabhoomi, in the case of Krishna Janmabhoomi and Kashi Vishwanath, the Hindus will be able to see the humiliation, the debasement every single day. This is what people want. And it is beyond any doubt. In fact, it is written in the most authentic biography of Aurangzeb, Basir-e-Alamgiri, that in January 1670, on the orders of Aurangzeb, the Keshav Dev temple, believed to be the birthplace of Lord Krishna, was demolished. Worse, Aurangzeb had the idols brought to Agra to be scattered under the steps of Jahanara Mosque so that they would be trodden on. Rahul, if the holiest shrine of some other religion was demolished and people of other faiths stomped their dirty feet on the sacred relics as they walked inside the place of worship, this country would have witnessed a civil war. The broken temple still exists. The broken idol still exists, and of all the disputed sites, the Keshav Dev, or the Krishna Janmabhoomi in Mathura is the easiest to decipher and educate. Let me explain very briefly why and how. In 1618, the Keshav Dev temple that was repeatedly destroyed by invaders like Ghaznavi and Lodi, who by the way ordered the idols to be given to butchers and used as meat weights, was rebuilt by Bir Singh Deo Bundela for rupees 33 lakhs, a princely sum in that amount, and 50 years later, as I said, it was cruelly destroyed by Aurangzeb. 100 years later, in 1770, the Marathas got control of the site after the Great Battle of Govardhan. The site then fell into the hands of the East India Company in 1803. That then auctioned the property to Raja Patnimal in 1815, with whose descendants the property remained till it was sold to Shri Krishna Janmabhoomi Trust under the auspices of Pandit Madan Mohan Malviya in 1944. In 1958, some devious politicians, some belonging to Congress, made a wholly fraudulent trust called Shri Krishna Janmabhoomi Seva Sangh that entered into an agreement with the Idgah Trust in 1968 and accepted a compromise wherein the Shahi Idgah's 2 acres of the 13.37 Krishna Janmabhoomi property would remain in the Muslim hands. It was Vishnu Jain and his father Shri Hari Jain who went from pillar to post, week upon week, month upon month, year upon year, to extract the original sale deed, and discovered that the real owner is Pandit Madan Mohan Malviya Shri Krishna Janmabhoomi Trust, and that the Shri Krishna Janmabhoomi Seva Sangh had no business to enter into an agreement with the Muslims in 1968. This was akin to, as Vishnu will tell you, Bunty and Bubbly selling Taj Mahal in that famous film. On 25th September 2020, Vishnu Jain and Hari Jain ji filed a civil suit. But a week later, on 30th September of the same year, the suit was dismissed by the judge. And you know what he said? That the judiciary will collapse if every Krishna Bhakt were to approach the court in such matters. So everyone can approach the court for CAA, for 370 abrogation, disputing it. But for Krishna, you cannot approach it. But the persistence of the Vishnu Jain and Hari Jain ji won the day. And their 3 years of struggle in the court has led to this day today and the judgment of Allahabad High Court. So this whole nation, our civilization, owes a huge debt of gratitude to Vishnu Jain and Hari Jain.
Okay, so let me bring in Mr. Vishnu Jain. You see, Mr. Varis Pathan has come out and said that, look, fine, all these things will be decided by the court.
10-second rebuttal to Anand Ranganathan.
Varis ji, ek minute unki sun le. Should we just listen to Mr. Vishnu Jain once and then you can come in? There's also Kamru ji, who's there with you, your cohort. So, though he comes from the Congress.
I just wanted to reply to my good friend Anand Ranganathan.
I'll just bring him in. I'll bring him in. You can have your face-off with him. There'll be a delightful face-off which you will get to have with Dr. Ranganathan. I know you guys like to square off, so I will not stand in the way, but I want Mr. Vishnu Jain to come in. Vishnu Jain ji, all this is fine, says Varis Pathan and his boss, Mr. Owaisi. All this is fine. But there is something called the Constitution. There is something called the law, and the law right now forbids Hindus to reclaim these properties. The only exception was made was for Ram Janmabhoomi. You people are paying scant attention to the law, which is the POW Act, not the Prisoners of War, even though this is some sort of imprisonment, let me tell you, for Hindus. But nonetheless, this is called the Place of Worship Act of 1991. Why are you ultra-virus of it, sir?
I want to ask a question.
Yes, sir.
Whether the courts of this country are not aware about the Places of Worship Act. What was the ruling of Varanasi District Court on 12th of September 2022? They said that in this case, Places of Worship is not applicable. What was the ruling of Allahabad High Court on 31st of May 2023? The Anjuman Intizamiya lost the battle before the Allahabad High Court. And this was the wording of the Allahabad High Court, that it is not barred by Places of Worship Act. When the matter travelled to the Supreme Court, I don't want to quote the Honourable Judge, but the Supreme Court observed that the Places of Worship Act does not bar ascertainment of religious character. So Rahul, today I want to ask on your channel, will you follow the interpretation given by the barrister, or you will follow the interpretation given by the courts of this country? I am bound by the interpretation given by the courts of this country. And it's not that the courts are not aware about the frontline defense of the Masjid Committee. They are aware that they are talking about the Places of Worship Act, but what they interpret about the Places of Worship Act, unfortunately it is not written in the Act. And to explain myself by way of an example, if I enter into a temple and I offer namaz there, will the religious character of temple change? Or vice versa, if someone enters into a mosque or offers a puja there, will the religious character of mosque change? There can be only one answer, that no, the religious character cannot change. And therefore, you will find such a unique case in this country where the ownership document, the title document is with the deity and the possession is with Shahi Idgah Mosque. Please ask a question to Shahi Idgah Mosque and Waris Bhai कि भैया आपके पास क्या डॉक्यूमेंट है, क्या आपके पास वक्फ डीड है? अगर है तो दिखाइए, मैं चैलेंज करता हूं, अगर वक्फ डीड है तो दिखाइए. दूसरी बात, can you imagine Rahul, that except by saying that we are offering namaz at this place, they have no other defense. Can you imagine that land of Allahabad High Court was declared as waqf property? The Allahabad High Court came to the Supreme Court in 2017. Like that, they are saying that this Shahi Idgah Mosque is a waqf property. And why it is a waqf? Because we are offering namaz. So wherever you will offer namaz will become a waqf land. It's completely against the basic tenets of Islam. Because as per Islamic law, a valid waqf can be done only by a person who has his self-acquired property, not by demolishing someone else's property. And last question to Waris Pathan. Please say on this channel that you can demolish someone else's property and construct a valid mosque. All the claims we will not fight.
Waris Bhai, please respond now to Vishnu Jain,
Yes.
and also Dr. Ranganathan.
yes.
And we will bring in Mr. Kamruzaman to ask
Well-
a simple question. Did the Congress collaborate to muddy this case? Okay.
पठान साहब मुझे 10 सेकंड दीजिए.
Well,
Yes.
Well, now let me respond to my good friend Anand Ranganathan and to my very good friend Vishnu Jain also. My friend Anand Ranganathan spoke about that earlier decades ago temples were destroyed and mosques were made in its place using force and everything. He made very point 10-15 minutes. But my learned friend Anand Ranganathan, the same arguments were canvassed during the Babri era. Same things were said that the temples have been destroyed and a mosque were built in place of the temple, but the Supreme Court unanimously held that there was no destroying of any temple. This was a unanimous decision of the Honorable Supreme Court. But the Supreme
Absolutely
Court
wrong.
passed an order decree to both the sides on the basis of Article 142, and the Places of Worship Act was enacted with an intention. The sole purpose was to ensure that now in future such kind of dispute must not take place. That was the intention. Now you don't want to follow the intention of the law laid down by the Parliament. You don't want to follow the Constitution. You want the faith of the people of the Hindu brothers and sisters. You have to ensure my faith as well. I am also a citizen of the country. What happened 4,000 years ago? That time there was no constitution. What Aurangzeb did or what the Hindu rulers did, what on the basis of swords, on the basis of whatever they must have done, you ask the questions to them. Today we have the constitution before us.
Arey bhai.
What was the need of
Okay.
racking up the issue
Two responses
now, when
coming
already
to you.
in the
You haven't
19
answered
in the year 1968
fundamental
the issue
point.
was settled.
Sir, the
In the year 1968 the
POW
issue
Act-
was
okay,
already
okay,
settled.
okay. Dr. Ranganathan and Vishnu Jain. Yes, Dr. Ranganathan first. Go. Yeah.
Yes, Pathan Saab is a very dear friend, but he's already lost 2 battles where he had to courier biryani to me. This will be the 3rd one. Because I asked him 2 very simple questions. One,
Today you will send me Mysore Pak.
okay, Mysore Pak. Pathan Saab, 2 very simple questions, then I'll come to your blatant lie that Supreme Court on the Babri Masjid. But just give me 2 minutes. Number 1, just very simply, please tell me who has the property sale deed of the Shri Krishna Janmabhoomi? Is it the trust or is it the Sangathan or Sansthan? You will not be able to say it because you will be lying if you say that Pandit Madan Mohan Malviya's trust does not have the deed. Now, if it does have the deed, how did the others
I will
get into
show you.
agreement? Number 2, you did not answer this question.
I will show
that
you.
if your holiest place of worship or a mosque was destroyed and a temple built over it, will you not approach the court to seek justice and to correct that historical injustice? You didn't answer that question.
Please answer.
And number 3.
This never happened. Nobody destroyed.
Now, please, Pathan Saab, this is unfair.
Nobody
because-
destroyed. That is why I say even during the Supreme Court.
So then, if there is another
See,
side
this
that
Sri
says
Krishna
that they want to
Janmabhoomi,
know,
I
allow
can
for the
show you
survey.
agreement entered between both the parties.
Allow the art, but that's
Other
not
than
the
showing
party.
agreement
That's an
entered between
interloper.
both the parties. If they were not into the possession, how would have they entered into this agreement? If you are not in possession of a particular thing, can you just go and enter into an agreement? That was not the issue that time.
Oh, no,
The
no, no,
situation was clear that they
No,
were
no, no.
into
It doesn't
possession
mean that if
and
you
they
no,
were
hang
having
on,
a
hang on.
dispute.
Okay,
as well,
gentlemen,
dispute was
lower
taken to the
everyone's
court.
figures. Let's
This
just
is what
let's-
I've got the petition
okay.
with me.
Okay.
I don't say orally.
No, one second. Viewers, at the heart of this issue are two claims. And I want to bring in Kamru Zaman Chaudhary. Kamru Chaudhary, this is an important point. And I want to ask you this because it's constantly coming up. The POW Act of 1991 doesn't forbid any move to ascertain the religious character of a property. That's all the court has done. Do you think the court is not aware of the Supreme Court, of the Act of Parliament? Do you think they work in a silo?
Rahul, good that you have asked this particular question to me. I was waiting to answer on this particular point of view only. You know, we all know the Supreme Court is supreme, but it is not fallible. Whatever the case out here, in this particular case, a section of the society like me, we all feel that this is particularly today's judgment from the Supreme Court refusing to stay the Allahabad High Court's order is a classic case of majoritarian supremacy, which despite the law, the High Court as well as the Supreme Court, Honorable Supreme Courts, have refused to acknowledge the Places of Worship Act 1991 with the fear, I feel, agonizing the majority out here. Why I say this?
Oh my gosh.
You just go back.
Need
Let
to
me finish.
answer.
I'm just taking just 10 seconds out here more. Let me tell you one thing out here. We gained independence in 1947. Baba Saheb Ambedkar had written a constitution for us to be followed. India as a nation existed from 1947, 15th of August. I agree with all of your point of view that Aurangzeb was a tyrant. The Mughal rulers who invaded India were all tyrants. They were looters, plunderers. They destroyed plenty number of places. But then what was the rule of, was there any rule of law out there? It was the rule of the sword out there at that point in time. Now,
And today
you tell me one thing, Rahul.
Today you are saying it's the rule of the majority. Just 1 second, we look at
No,
the absurdity of this.
Rahul,
One second.
please.
The entire
I won't
Hindi,
finish my
one
point.
second. The entire Hindu community has a problem with state control of their place of worship. They have a problem, viewers, with the fact that the court interfered in their religious beliefs. At that time, the court was not scared of a majoritarian backlash. Right now, they're quaking in their pants. Ridiculous. Look, I'll leave it at this, viewers. I don't want to get into an area where the court is already looking at a particular aspect of the law. But I can tell you one thing. Only the truth, if it is excavated and surfaces, can settle this dispute. Anyone who's trying to obstruct that process, perhaps, is doing it out of some sort of malified interest. Naturally, viewers, who gains from obscuring the truth? The truth is the greatest leveler. Something is up here. I don't know.